A very good morning to all. I'm Nishta Sharma, the Research and Program Coordinator for CIIPC, National Law University, Delhi, and I would like to extend a warm welcome to everyone present here for the inaugural session of the launch of the Joint Masters LLM in Intellectual Property, Law and Management. Thanks to all for joining us today. I would like to welcome on stage Dr. Yogesh Pai, Associate Professor of Law, for delivering the welcome remarks. Over to you, sir.
Thank you, Nishta. A warm welcome to all of you for the launch of the Joint Masters/LLM degree program of National Law University, Delhi. So this program was conceived and conceptualized as a joint partnership between the World Intellectual Property Organization, National Law University, Delhi, and the Office of CGPTDM under the WIPO India Action Plan 2024 last year. So with the letter of intent, we started working on the nitty-gritties of the program, and today we are here for the launch. And today is also the date when we are starting the applications, and we are keeping them open till June 3rd. So I welcome you all once again. So with us is Honorable Vice Chancellor, my beloved Vice Chancellor, Dr. Professor G.S. Bajpai. The chief guest of today's function is Madam Honorable Justice Pratibha Singh. And we have two special invitees and who have been associated with the program. That is Professor Dr. Unnat Pandit, who is the Controller General of the Office of CGPTDM, and Dr. Pushpendra Rai, who he is formerly with the WIPO and now with us, helping us to deliver on the program. And he's also an international IP advisor. So briefly, people on the dignitaries on the panel, dignitaries on the dais need no introduction to the IP world. But I would try and do a little bit more in terms of the introductions, starting with Professor Bajpai. Professor Bajpai is Vice Chancellor NLU Delhi. He was previously also the Registrar of NLU Delhi, but in between, he was at RGNUL Patiala. It is under Professor Bajpai's leadership that this MOU was signed last year. And Professor Bajpai is a phenomenal academic. He is a criminologist by background. He has more than 20 books to his credit, and he regularly writes in newspapers, including the Hindu and Indian Express and many others. And I'm sure those who are at the interface of law and social sciences, you should look forward to Professor Bajpai's work. So he has been one of the early elected Secretary Generals of the World Victimology Society, and he also is the head of the center at NLU Delhi on Center for Victimology. Today's chief guest, Justice Pratibha M. Singh, ma'am is the permanent judge at the High Court of Delhi, as you all know, and she has a great legacy to show even before she joined the bench. While she was in the bar, she was part of India's national IPR policy, and she worked along with a team of people to deliver on the policy. And then after the launch of the policy and many years later, she was appointed as the judge of the Delhi High Court. And very recently, all things apart, you may know about ma'am. She has also written a very wonderful book, which I got a copy and I read through some chapters, and it's phenomenal. So those who are interested in intellectual property law, particularly patent law, must definitely go through this book. Madam Justice Pratibha Singh was also rated as one of the most powerful women in business in 2013 by Asia Women in Business Law Awards. And then she was also the most 50 influential people in IP in 2022. So with us is also Professor Dr. Unnat Pandit. Again, those in the IP world get to interact with Professor Pandit on a day-to-day basis because of the IP prosecution work that some of you do. And Dr. Pandit, as you may all know, has an academic background also. So prior to taking up his position a couple of years back as the Controller General of Office of CGPTDM, he was leading the IP head, IP cell, as the head of the IP cell at Jawaharlal Nehru University, Delhi. And previously, he was also associated as a program director of the Atal Innovation Mission. And he was also the part of the National IPR policy in 2016. So I'm glad that you could join. Dr. Pushpendra Rai is also with us. So as I mentioned, Professor Pushpendra Rai is a globally renowned authority on intellectual property. He has worked at the World Intellectual Property Organization, Geneva, And previously, he has served as an IAS officer with the Indian government at various levels, including when he was the Joint Secretary supervising the office of CGPTDM. Now, he has many laurels to his credit. As the director of WIPO, he headed the WIPO's economic division. Between 1999 and 2015, he also coordinated WIPO's activities and studies. And today, he facilitates as an international IP advisor based in Delhi. Thank you very much all for joining in today. So, with with this, what we are going to do is to tell you a bit about the program itself. You will see that in the brochures very quickly, but this program has two tracks or dual tracks. One is the masters for those who are eligible through the BA LLB background, and the other one is for other disciplines. So this has been conceptualized to accommodate not just the legal fraternity, but then other aspects of the IP ecosystem, which we often, do not consider as very mainstream, and to get other people also with technical background, particularly TTOs working in SMEs, etc. This program offers the dual track, wherein both law and non-law students and candidates can participate. There is no age bar, so anybody can apply. The second important thing is the global nature of the program, which means we have global faculty on board and we follow what is called as block teaching method. It is interdisciplinary in character, and the program has a particular rigor to it. Primarily, if you look through the structure of the program, the brochure, you will understand that the topics, the subjects are very contemporary in nature. So I welcome you all once again. I see many people here today who have joined. I would first of all like to thank those who have agreed to do kind of a full-time work with us as visiting professors. And these are largely academics from different parts of the country and also the world. And then we have our guest faculties. Now, recently, when I met ma'am at the Delhi High Court, she said she would also be interested in teaching, and that surprised me. And I, because I was thinking, how should I ask ma'am for her time to come and teach? And I thought it would be, I would be, but then it came from her. And that really tells you that she also has an academic mind. And that also is reflected in her book, which she has recently written. So thank you, ma'am. And along with the judiciary, we have also invited various other people, senior practitioners. I can see some of you here who have agreed to join us as guest faculty. Thank you so much for joining in today physically. The session is also live, so those from the audience who cannot actually attend the session, they are joining us live. So I welcome all. I also welcome members who have joined online through World Intellectual Property organizations and other places. Thank you all. So may I request our Honorable Vice Chancellor to felicitate the dignitaries on the dais today, starting with Honorable Justice Pratibha M. Singh, Chief Guest of today's function. Professor Unnati Pandit. Professor Pushpendra Rai. One for you. Oh, thank you. So we will now Yeah. Thank you.
Thank you, Dr. Pai. I would like to welcome on stage Vice Chancellor, National Law University Delhi, Professor Dr. G.S. Bajpai for the
Inaugural.
inaugural address.
Ah, sorry.
Very good morning to all present. And at the outset, I wish to thank everyone for joining in this inaugural session of the launch of Joint Masters and LLM program on intellectual property law and management. I wish to particularly thank our chief guest, Honorable Justice Pratibha Singh, Judge, High Court of Delhi, who has taken time out of her busy schedule on this weekday. It only reflects on her sense of commitment to academic learning and overall holistic development of the IP ecosystem in India, in which IP education is a core component. I also heartily welcome Professor Dr. Unat Pandit, Controller General of India's IP Office, and Dr. Pushpendra Rai, an international IP consultant who was formerly with WIPO's senior management and is now closely involved in shaping the program at NLU Delhi. So the launch of this program has been in the making for quite some time now. Previously, when I was the registrar at NLU Delhi, I distinctly remember that we expressed our initial interest to host the program. The DPIIT, Ministry of Commerce and Industry, Government of India. However, I am very happy to state that although it took quite some time to crystallize and fructify, this was one of the first things we initiated since I took over as the Vice Chancellor of National Law University Delhi early last year. I can't be thankful enough to Professor Pandit, who took leadership in convincing the higher authorities of the Ministry of Commerce and Industry to bring this program to India under the WIPO India Action Plan 2024. I'm glad to state that Professor Pandit and his team worked very closely with our team and faculty at the National Law University Delhi in making this happen. He has been a constant source of support in getting the program started at the National Law University Delhi. After all the work done in the background, and I should not forget mentioning Dr. Yogesh's role. In the background and in the foreground, he has been working tirelessly for this, and his passion was something which inspired all of us to come together to launch this program. So, big round of applause to Yogesh. And the aim and vision of this degree program is to move beyond the conventional constraints of education centered primarily around content delivery and focus on enabling the students to actualize their full potential to contribute to the field and society in general. We at NLU Delhi are now making it possible for many aspirant students to build a career in IP by way of a specialized master degree program, which is global in its reach, cutting edge in its content, and path breaking in its pedagogical approach. Being a multidisciplinary university focused on law, an interdisciplinary program in IP law has been purposely blended with the core IP management practices. So it is my firm belief that it will raise the bar in achieving unparalleled academic excellence in times to come. As you may notice from the program brochure which we have just released, the program has an exceptionally global character due to the curriculum requirements, expertise offered, and opening it up to foreign nationals, particularly from Indian Ocean region. This is the part of NLUD's growing emphasis and effort towards internationalization of the curriculum and campus to suit the increasing societal demands, which is extremely connected in technological world that is well integrated with global knowledge economy. I must say that the faculty teaching this program is one of the highlight of this program. Because I discussed with Yogesh that what would be the faculty structure for this very ambitious program. I thank the visiting faculty who has come together now to support this program, and they have agreed to teach by offering their valuable time and expertise. Their profile speaks volume of their expertise and interest in the development of IP academia in India and in this region. The block teaching method has enabled this variety of global participation. Otherwise, their involvement was difficult. So we have conceptualized this pedagogy of block teaching for this program. Similarly, I must mention how thankful I am to the guest faculty members, particularly considering their seniority, wisdom, and expertise, who have kindly agreed to associate with this program and offer their time. I can only imagine this motivation to transmit real world knowledge and build a generation of new IP practitioners and professionals only stems from their level of love and their innate sense of contribution to society at large. I'm sure skill based courses and clinical courses will specifically benefit from the involvement of our esteemed guest faculty. You may also have noticed that the program is offered in a dual track mode for law and non-law students. I can totally relate to how important it must be for non-lawyers to study and integrate the concepts of law and innovation, economics, management, and public policy. IP is increasingly an ecosystem challenge in India, and the law cannot and should not be devoid of the context in which we live. I personally think this is one of the major highlights of the program. The kind of subjects introduced are contemporary and cutting edge. By jointly collaborating with World Intellectual Property Organization, the specialized agency of the UN on intellectual property, and of the Controller General of Patents, Design and Trademarks, which is the intellectual property office of the Government of India, we are bridging the gap between expectations of the society, demands of the profession, and skill sets imparted. NLU Delhi, I'm sure, is well positioned to deliver on the synergies created by collaborating with the prestigious partnering institution. This assurance rides on the background of NLU Delhi's academic ranking and reputation. I'm very happy to share for past 6 years, this university has been ranking in NERF framework for at number 2 in the country amongst more than 4,000 law teaching institutions in the country. Continuing with this tradition of enabling excellence in higher education, NLU Delhi students have achieved various prestigious scholars. I can mention in the recent past, the students have won the Rhodes and Cambridge fellowships, particularly in the field of IP, apart from excellent in-house practitioners, litigators, and other IP professionals. In recent times, we have taken a number of new and landmark initiatives. I'll very briefly give you an idea, such as Eklavya. Eklavya initiative is very unique initiative, which is a research affiliation program. There are Eklavyas outside of the world, outside of the institutions, who are always willing to be associated. We have enabled them through this program. Abhyasa is a very important initiative to involve practitioners in imparting practical skills to students. Anubhuti, an initiative for students to work with various centers, chairs, and faculty-driven research projects at NLU Delhi. And Saksham is another initiative to enable students, including students with disability, to cope up with the needs of the academic program. In my opinion, these remarkable initiatives at NLU Delhi herald new ways of thinking about education in general and legal education in particular. I must particularly acknowledge the work done by the Center for Innovation, Intellectual Property and Competition at NLU Delhi and the IPR chair constituted by the Ministry of Commerce and Industry. If NLU really can launch this course today, I stand assured that it will be run successfully by our faculty in association with our visiting and guest faculty. I also acknowledge the efforts of our faculty in collaborating successfully with two key institutional partners who have worked very closely. The kind of orientation and thought process needed to teach the multidisciplinary course needs a lot of reimagination. So today is the new beginning. I specifically wish to thank the panelists who will speak in the next session today on reimagining IP teaching in India. I'm sure as the academia practitioners and IP experts deliberate on how IP teaching in India should be reimagined, I am reminded of the promise that education is meant to transform human beings by expanding their horizons and causing paradigm shifts in the thought process. We believe this is reflected through the core values of education at NLU Delhi. Any candidate equipped with joint masters and LLM in IP law and management will be able to see a different world with not only career opportunity in IP law through an LLM degree, what candidates from non-legal background will find themselves well positioned to deal with IP careers in real world, which often cross-cuts many areas of technology, business, entrepreneurship. What this program offers is very exceptional and unique in this academic sphere. I'm proud that NLU Delhi has been at the forefront of the institutional partnership to deliver on the program in this region. Not only candidates from India will benefit through future opportunities by enrolling themselves in this program, but foreign students will certainly especially benefit as they will be able to stand out in their respective countries through expertise, leadership, and dynamism instilled in them after taking this program. I would again thank the Office of CGPDTM, Ministry of Commerce, Industry, Government of India, and particularly Honorable Commerce Minister Shri Piyush Goyal ji in taking interest to get this program under the WIPO India Action Plan 2023. As we begin this course in August 2024, the applications are now open. I encourage all present here to offer wider publicity to this program. Being a public university, this program is a public venture, and all present here are equal stakeholders in ensuring the success of this program. I again thank you all for joining us here and tuning in live on other YouTube channel. I wish the Joint Masters LLM program all success and all the best to our prospective students. Thank you so much.
Thank you, Vice Chancellor, sir. I would now like to welcome our esteemed chief guest, Honorable Justice Pratibha Singh, High Court of Delhi, to deliver her address. I welcome you on stage, ma'am. Thank you.
A very good morning to all of you. When I entered here, I told Professor Yogesh Pai, aren't you all bored of seeing me? So I would just like to start by saying, felicitations to my entire IP family, which is, every person in this room is almost known to me, I think. So I wouldn't want to address everyone separately. And it's really a pleasure to be here. Even before court hours start in the morning, this is such a watershed moment insofar as IP education in India is concerned, because it has always been such a requirement in the IP ecosystem to have specialized courses for LLM or maybe even for LLB with focus on IP and with in-depth study of IP. And it's such a heartwarming thing when I see the brochure of this. It's a joint effort by none other than our own NLU Delhi, because the NLU Delhi belongs literally to the Delhi High Court. And the Controller General's office, who again has been such a, encouraging person in terms of taking steps for reforming IP. And of course, who else but the WIPO. I must acknowledge the presence of Dr. Pushpendra Rai. He, along with, people like Dr. Narendra Sabharwal, Mr. Naresh Prasad, who also passed away, unfortunately. These are people who have laid the foundations for the India-WIPO collaboration and arrangement over the last not 1 year, 2 years, 3 or 4 decades. We are today actually seeing the fruits of their labor over so many decades that WIPO is in India. And when else than the present year of 2024, we've had some really amazing programs in India in general and in the Delhi High Court in particular. The end of last year saw the visit of the Director General of WIPO, Mr. Dan Tang, to the Delhi High Court. He and his team visited the Delhi High Court, met all of us judges. We all welcomed him under the Chief Justice at that time, Mr. Sharma. And that led to the WIPO Masterclass being brought to India for the first time. The WIPO Masterclass is a unique initiative which collects judges from different jurisdictions in a masterclass discussing IP issues in depth. India is the fourth country, and the Delhi High Court is the fourth venue to have hosted this globally since it began. The first one was in DC, Washington, DC, then in Beijing. The third one was in Munich last year, and this year it was in the Delhi High Court just 10 days ago. We had judges from 21 jurisdictions and almost all the 5 high courts in the country. Total of 36 judges participated on over 3 days of intense discussions of WIPO. I mean, the legends of IP were here in terms of judges. Professor Dr. Hannibal Bennett, Dr. Colin Burrs, the president of the UPC, Klaus Gabrinsky, they were all here. And it was wonderful to have the entire IP global legends in our court. Then, of course, that was preceded by the Danish embassy's visit to the Delhi High Court. Louis is here. And we had a wonderful interaction with all the commercial court judges, with the Danish experts who came from Denmark. After the WIPO thing was the Indo-UK collaboration, where we had various judges, including the Master of Rolls himself in the Delhi High Court. And Pragya is here from the UK Embassy. And and finally, we had the Indo-US IP event, where Kathy Vidal, the IP head, and the US ambassador hosted us, and we had a 3-day conference for more than 200 to 300 IP judges from Southeast Asia and from India. So, I mean, this has been one of the most landmark years to start with for IP, and the icing on the cake is today, with the course beginning by the NLU Delhi and with the leadership of Professor Yogesh Pai. And I must congratulate all the 3, i.e. the NLU Delhi, the CGPTDM, as also the WIPO, for having commenced this program. And I think this is going to go a long way. And I think this is going to expand. I would look at NLU Delhi maybe having a separate building for IP law and IP LLMs. That's the way it's going to be. And, I really think that the course couldn't have come at a better time, because we've actually broken several records. And I'm sure Dr. Unnat Pandit will tell you about his filings and everything. Just giving you a context, with the abolition of the IPAB, even the IP filings in commercial courts and in the high courts has increased substantially. The statistics will tell you all that. The annual reports of the High Court are being now published and made accessible online. So you can take a look at it. Some of the landmark judgments are coming out of various high courts. Complex issues of 3I, 3K, etc. are all being adjudicated with ease. And we've now recruited law researchers with scientific background in the Delhi High Court to assist judges. That recruitment first round has happened. We hope to start the second round soon. So these are all things that are happening which are building our IP ecosystem. And IP education, let me tell you my experience as a practitioner. As a practitioner, I always felt we needed more IP litigating lawyers who had a scientific base. Because without a scientific base, it is very difficult to litigate on complex issues of patents. So we need multidisciplinary courses. If you go in any other country in the world, you'll see most of the IP patent litigators would be science background. They could be engineers, they could be physics, biochemistry, biotechnology with law, and then that's how they start being. Now we are actually, some of the lawyers in this room are with scientific degrees, and I think that the manner in which IP education has to go forward should be multidisciplinary, whether it is science, whether it is economics, whether it's chartered accountancy, because in patent litigations or in trademarks or in copyright litigation, people without backgrounds of how to evaluate damages, how to compute, how do you say whether a particular offer made by any company is a reasonable offer, it's a unreasonable offer, whether it's a friend offer, how do you calculate damages, how do you calculate rendition of accounts? All this requires multidiscipline. And without multidisciplinary courses, IP litigation cannot thrive. And I think apart from litigation, I look at IP in the corporate world. Some of the corporates, including Sheetal, is here. So the thing is, in all these companies, you need people who can be uh, helping researchers in their own companies, helping IP developers, IP creators in their own companies to be able to guide them as to how to, register patents, register designs, register copyrights and trademarks, and then enforce them as well. So management plus IP is very, very important. And that's when I think this course is very crucial in building a new breed of professionals who are not just engineers and MBAs, but now engineers plus IP lawyers and management consultants. So these are really amazing combinations. And I think it's very important that we have these courses. I must emphasize one important thing. Most of the young lawyers today who aspire to get LLMs abroad have to spend so much money. They cannot afford it. It's just unaffordable for any middle class family. But they do want to study in IP. So what else than in LU? Really, I've just seen the program content and the coursework and also the faculty. And with the globalized nature of the faculty, I really think that this is a time when all our youngsters should be having enough opportunity to study in the best institutions and be taught by the best professionals and faculty. And that's why this course, I think, will go a really long way in making IP education affordable in our country. And I would literally, ask almost all law colleges, national law schools, including the IITs and IIMs, to have IP courses for their students, because I think all the IITs will become more relevant if they teach IP. So having specialized courses even in all these science-based institutions is the need of the hour. And we should build on the kind of foundations that have been laid. And I can today see a room full of serious IP professionals, whether they are international organizations like INTA or the USPTO, where Shilpi is here. So many, the officials from the IP office who are sitting with us, the faculty from NLU Delhi, IP practitioners. This is a multidisciplinary hall audience in any case. I mean, each of you is an IP professional who is seriously working for the cause of IP. And I think this can only be successful as we go forward. We also have to have the commitment to be able to spare our valuable time to make the course very successful. I think as IP professionals, we all earn enough during our profession. And even if we are judges, even if we are lawyers, we need to spare time to make sure that these courses become successful, because that is how we are going to have a new breed of IP lawyers in our country, whether they work in-house, whether they work in policy, whether they work in academic institutions, in the courts, either as judges or as lawyers. We need a full new breed. And this LLM will really go a long way in building such kind of a breed of IP lawyers. So there are a few more things that I just need to emphasize before I stop for today. I believe that India is now the leader one of the leaders in the Southeast Asian hemisphere to be able to focus on IP and innovation. I don't think I need to speak about innovation here. The last 10, 15 years, I've really seen huge growth in innovation. I can see the difference in the last 4 years at least, with the startups ecosystem, with the expedited examination, with the, for women inventors, there's so much more focus. And I think all this is going a long way. The strengthening of the WIPO India partnership is a very significant milestone. And this would actually lead to India having a bigger role to play in the international dynamics of IP. And for that, we need a large number of professionals who should be able to assist our country and work for our country, either as part of negotiating teams or as writing in publications in whatever manner. So all that adds to the way India is going to grow as an IP leader. And I want to say one last thing. IP is not about just making money. IP is about being extremely responsible. That's why my book ends with the word responsible IP. So, responsible IP means we need to also cater to the masses, not only in India, but in the whole world. India has always had that, altruistic perspective to IP, and we should continue with that. And with the growth of climate change, water scarcity, environmental issues, all this IP and innovation is very needed, but the dissemination and the ensuring of implementation of these new technologies for the growth and the benefit of the society in general is something that IP should focus on and IP professionals should focus on. And I would just think that the course will do extremely well, Professor Bajpai. I'm really hoping that all the people who are here will spread the message about this course and get the best talented students for the LLM. Because I remember as the first batch of the University Law College Bangalore, we took the 5-year course to a different level. And I think the first batch always matters as to how the course, the chart of the course goes. And I really wish NLU Delhi all the very best. Under both of your leadership, I think that it will do very well. And the students who come in, please keep them completely involved, keep them busy so that they can study IP. I can see the coursework that you've got, very interesting topics, monetization, valuation, taxation, competition law. All of these are the, going forward subjects which we all need to understand. And I would just end by saying, alone we can do a lot of things, but as a team, which is what this course is about, teaming up of 3 different organizations, we can do a lot. And heartiest congratulations once again to all the 3 institutions involved in the setting up of this course and wishing it all the very best. Thank you so much.
Just before we move to the special address, I also wanted to acknowledge, because Sir mentioned about scholarship, I wanted to acknowledge the presence of JETRO's representatives here, Watanabe-san and Jenica, who have, the government of Japan has generously sponsored. Yes, yes. So they have sponsored, I have mentioned it in the brochure, they have sponsored scholarship for international students, and we thank them for their presence here. Okay.
I must then mention JETRO. JETRO has been an organization with whom we worked so much in the last 5-7 years. And I'm sorry, I don't think I acknowledge both of you. It's really nice. Japan and the Japanese Patent Court. Delhi High Court has worked closely with them. We've done mock trials with them in the last 3-4 years. And it's really nice that you've given a scholarship.
Many thanks, Madam, for your insightful thoughts. I would now like to welcome Professor Dr. Unnat P. Pandit, Controller General of Patents, Designs and Trademark, Ministry of Commerce and Industry, Government of India, to the stage.
So I will save the energy and also the space and discomfort. Will try to share my views sitting on this chair. This is a great beginning, which was visualized in 2014-16 when the national IP policy was getting drafted. And so much of a discussion which was happening, Pratibha ma'am is aware about this. And in seventh objective, human capital development. So not the human resource, it's a capital which needs to contribute to the country's economic transformation. And in that objective 7.10, there was a need which was visualized that we need the strategic IP teaching and collaboration with the international institution. WIPO was mentioned. So from that, it was a continuous efforts which were put into the practice. And as a result of that, the WIPO India action plan was also triggered. And with the visionary leadership in DPIIT also, the WIPO India action plan was signed. And one of such objective, we have thought that when we are signing this WIPO India action plan, we should also sign off an tripartite MOU. And in this particular program, so immediately within a few minutes, the MOU was also signed. And within a few weeks after that, the discussion got triggered and a well thought program is now the reality. And there is a need for the country also. We have crossed 1 lakh patent grant just few days back in 1 year. We have a more than 90,000 patent applications getting filed in India. That means at every 6 minutes, one scientific research or technology is showing their interest in the Indian economy. And that is the true spirit in which the Indian economy is growing. On each working day, more than 250 patents are getting granted. That shows the change in the perception in the IP administration. The way we are reviewing, assessing, the mindset change which was required. And this was taken up under the Mission Karma Yogi initiative, which Government of India has taken up. Under the Mission Karma Yogi initiative, we have developed the annual capacity building plan. And in this program, our officers are also going to pursue this Joint Masters or LL.M program. And that's how, along with the professionals who are in the field, our officers are also going to pursue this program. The topics which are taken up, IP licensing, IP monetization, the interesting and most favorite, IP economics and innovation and new business models. This is the future need for the country, and we will be requiring the human capital to think on those lines, that how we can create the economic benefits out of the IP. In our budget speech, Honorable FM has also mentioned, not this year, but in 2022, that India wants to grow as technology and knowledge embedded economy. And for this technology and knowledge embedded economy, I believe the IP is the key to open the door. And IP being a key to open the door, we need the fully equipped people who are going to enable this. And those human capital development, which was visualized in national IP policy, will start practicing, pursuing this program. So the people who are online also, the applications are open. So now those who are interested, they need to join the program. They need to contribute in this program, a very exhaustive learning and interactive planning has been done by the program director Yogesh Pai. So this is going to be a much useful. One of such element which has been introduced here in this program. While designing this program, I discussed with Yogesh Pai that we also need to have a IP examination, IP office administration and management. So not just our officer learn the new approach which we want in the IP administration, but equally the professional people also need to learn how the office is functioning and what is their thoughts. So we want to seed this corporate governance model in IP administration. And so far, many initiative IP office has taken. But again, Professor Vajpayee and Yogesh Pai ji, this is the program which is going to change the entire IP teaching in the country. And I can see this is a new beginning, and this will also get replicated in the other premium legal institutions to have the multidisciplinary education, which is very much enabled under the national education policy. So very much alignment of a national IP policy, national education policy, and our WIPO India action plan. So perfectly aligned program is now being offered under the aegis of NLU Delhi. Thank you. Thank you very much.
I have to apologize, I have to leave now.
Yeah.
Yeah. You can just continue. I don't know. Sorry. Please continue. Thank you. Okay, you also. They're with me, my last.
Sure. Thank you. Thank you.
Many thanks to Professor Pandit. I would now like to welcome Dr. Pushpender Rai, former Director WIPO and International IP Advisor, for his address. I welcome you on stage, sir. A round of applause, please.
Good morning, Honorable Justice Pratibha Singh, who's just left of the Delhi High Court. I wanted to congratulate her again on her new book, Magnum Opus. Dr. G.S. Vajpayee, Vice Chancellor, National Law University. Dr. Unnat Pandit, Controller General of Patent Designs and Trademarks. Dr. Yogesh Pai of the National Law University. Distinguished guests, ladies and gentlemen. It's a pleasure to join you today at the launch of the first dual-track Master of Laws and Master's Degree program in Intellectual Property Law and Management. I take this opportunity to convey the warm greetings from WIPO Director General Darren Tang, Deputy Director General Hassan Clive, and Executive Director of the WIPO Academy, Sharif Sadallah. I thank the Government of India for their support in making this program a reality, and our hosts, the National Law University of Delhi, for their unwavering commitment to IP education. I also wish to acknowledge the contribution of the Government of Japan through their Funds and Trust program for supporting the provision of some scholarships to this program, as already mentioned by Dr. Pai. WIPO's vision is a world where innovation and creativity from anywhere is supported by intellectual property for the good of everyone. WIPO's mission is to lead the development of a balanced and effective global intellectual property ecosystem to promote innovation and creativity for a better and more sustainable future. Balanced and effective have virtually become the mantra for the organization, especially since the adoption of the WIPO development agenda in 2007. WIPO's medium-term strategic plan emphasizes the importance of increasing IP knowledge and skills in all member states. The WIPO Academy plays a central role in this regard. It is now the world's largest provider of IP training and skills development with about 1.2 million people having benefited from its programs. And Indian students, of course, have been a great beneficiary of the Academy's programs. And in the last 5 years, about 80,000 participants from India have taken the distance learning programs of the WIPO, which is one of many programs organized by them. And the Academy's goal has been to prioritize IP education for everyone, everywhere. And this program will help to advance its mission by making IP higher education available and accessible to participants from India, the region, and the world. India is undoubtedly a fast-growing powerhouse of intellectual property, as represented, for instance, by its patent filings. Dr. Pandit has talked about the domestic filings just now, how the numbers have been going up. In 2023, among the top 15 countries, Indian innovators filed about 45% more PCT applications, the Patent Cooperation Treaty, than the previous year, following a 26% growth the year before. Against this background, this program could not have come at a more strategic moment as the first dual-track program to be offered for law students and others with a non-law background. This approach will provide an opportunity for non-law students to enhance their knowledge of IP and make an impact in their communities. Inclusivity is important for WIPO and our partners because IP has previously been considered as a subject reserved for specialists and legal experts. WIPO has been striving to change this perception in order to make IP more accessible and relevant for all sectors of the economy and the society at large. By focusing on IP law and management, this program provides a unique opportunity for students not only to acquire knowledge in the core areas of IP law, but also for strategy and management of IPR. It will cover modules relating to IP and various facets like licensing and contract management, monetization and valuation, strategic asset management, advanced acquisition, commercialization and technology transfer, enforcement and dispute resolution, and intelligence and analytics. Distinguished law and management experts engaged by WIPO have made valuable contributions to the development of the curriculum and syllabi for this program. Their contributions ensured that the program design promotes creativity, innovation, and imparts IP knowledge to young professionals, entrepreneurs, and SMEs for strategic use of IP from conceptualization to commercialization. This will be the WIPO Academy's 14th Joint Masters program, adding to the existing bouquet of programs established globally. The Academy's goal is not only to impart theoretical knowledge, but also to complement it with practical skills, ensuring a comprehensive education. I am confident that the partnership between the WIPO Academy, the National Law University Delhi, and the Controller General of Patents, Designs, and Trademarks will ensure that this unique dual-track master's program will become a great success and leading example of using IP as a power tool for growth and development. Thank you very much.
No, I think there's no problem. Let's take it. Thank you. Yeah, before we move on to the vote of thanks, I just wanted to acknowledge our guest faculty. So the reason why I could not incorporate all the names is because the confirmations were coming, so we had a risk of running, mentioning somebody and not mentioning others. But I would really like to acknowledge starting with Ankit. I can see Professor Raman Mittal, who is associated. Dr. Malti Lakshmi Kumaran from LKS, very senior person. She is associated with the program. Professor Suma Atrai, I think she's already contributing through her visiting faculty. Then we have Gauri. We have who else do we have here? Sheetal has agreed. Rajeshwari Madam has agreed for as a litigator. She would contribute. Adarsh Ramanujan, I can see here, and then Madam Lata Nair. I see Aditya, Sunita, and Abhilasha. Did I leave out someone?
So I really wanted to acknowledge your presence here today. Thank you very much for being willing to be associated as a guest faculty. Since this is going to be in the block teaching method, I know your time is precious and you all do it for the labor of love. But then, this is going to be a great, immense contribution from your side, and we are extremely thankful to all of you for doing this. Thank you so much.
Ladies and gentlemen, our distinguished speakers and our valued participants, as we bring this inaugural ceremony to a close, it is a privilege here to stand here before you and extend a vote of thanks for the launch event of the Joint Masters LLM in Intellectual Property Law and Management. First and foremost, on behalf of everyone present, I would like to thank Professor Dr. G.S. Bajpai for delivering the inaugural address. Sir, your words of wisdom have set the tone for the commencement of the program. I would also like to express a profound appreciation to our esteemed Chief Guest, Honorable Justice Pratibha M. Singh, for taking out time from her busy schedule and joining us today. In the insights shared by Pratibha Ma'am and her expertise about the dynamic realm of intellectual property is truly valuable, and we were lucky to have her here today with us. I would like to thank Professor Dr. Unnat Pandit, Controller General of Patents, Designs, Trademark, Government of India, and Dr. Pushpendra Rai, former Director, WIPO, and International IP Advisor, for enriching the discourse with their special address. A special thanks to our partnering institution, Ms. Martha Chikavore, Mr. Victor Ovare, Ms. Hetvi Trivedi from the World Intellectual Property Organization, and Dr. Amrendra Samal and his team from the Office of the Controller General of Patents, Designs, and Trademark. Thank you very much for your continued support. Today's event has been months into making, and this would not have been possible without the guidance and visions of Dr. Yogesh Pai, who is the program director for this program, Associate Professor of Law, National Law University, Delhi. A very warm thank you to you, sir. Many thanks to Vice Chancellor, sir, and Registrar, Madam, Professor Ruhi Paul, for their continued support and encouragement, without which this would not have been possible. Last but not the least, I owe a debt of gratitude to the organizers of the event who worked tirelessly to ensure that everything was functioning in a seamless manner. Ms. Gunveen Kaur, the CIIPC team, IIC, and NLU Delhi for ensuring that this was executed seamlessly. Finally, no event is complete without the participants. So very warm thanks to all the participants for taking out time and joining us today. I would like to request everyone to join us for high tea, and we will reconvene in 20 minutes for the panel discussion on reimagining intellectual property teaching in India. Thanks to all. Now you for handing out the monitors.
We can last week
Last at the very
bouquets भी है ना
at the very end.
एक काम कर सकते हैं जब बुकेज भी है बुके से शुरू करते हैं और वो भी दे
End
देते
में start करेंगे.
It's better.
मैंने बोला कि मॉडरेटर को हमको जो मिले थे उसमें
Yeah, Yogesh was fine.
Yes.
Actually, yesterday, one of our students brought one.
Okay.
अभी खत्म we have one
Krishna, I'll start first. We'll just start saying, we'll begin with the panel discussion on the imagining attitude. Like, request the moderator of the session to do that. Then I will start the introduction and reading out their slides. 85 के बाद 80 पर एक करते हैं. Let's start. Nishna, let's start.
Welcome back, everyone. So we will now be beginning with the panel discussion on reimagining IP teaching in India. I would now like to hand over the session to our moderator, Professor Dr. Yogesh Pai. Over to you, sir.
Thank you, Nishta. Again, warm welcome. So due to time constraints, many who were attending the court and others who had very pressing commitments had to leave. But I'm very glad that many of you have still stayed back, and it's really wonderful to see that particularly practitioners and those who have this is a court day, particularly and others who are who have other engagements have stayed back. Thank you so much. So the idea for this panel discussion, reimagining intellectual property teaching in India, actually comes from my professor, whom I have to acknowledge today, Professor N.S. Gopalakrishnan. And frankly, I think some of us, I can see Sunita here, Lata, you are also, yeah. So he's one of the first generation intellectual property teachers who taught at NLS initially, National Law School of India University, and then went on to teach at Cochin University of Science and Technology. And that's where I met him. And he really transformed the way in which intellectual property teaching happened. And it was his master's program that he designed and conceptualized that that produced mighty practitioners and also a lot many academics. And today I acknowledge, him. He could not come. In fact, I had invited him, but then he had foreign travel at this moment, so he could not join. But I have sent him the link and hope he's joining online in the YouTube channel. With those acknowledgements, I would also begin with the idea of what he conceptualized as reimagining intellectual property teaching as a kind of a workshop every year. And that gave me some inspiration into, rethinking how intellectual property teaching has to happen within this program, and what can be the right set of right balance that we need to, have between theory, practice, also between doctrines and applied, applied law, and also from a non-law perspective, looking into how intellectual property is actually managed in technology transfer organizations, in SMEs, in R&Ds, in labs, incubators, etc. So that's one of the reasons why we thought we should make it multidisciplinary, because the idea actually, and frankly speaking, in fact, I acknowledged it when we signed the letter of intent, that is the memorandum of understanding with the World Intellectual Property Organization and with the CGPTDM, that this was through what do you call the WIPO India Action Plan in 2023, but the roots go back even further back, even before the national IPR policy. In fact, he was the one initially said that we need to get this WIPO program, and he tried. But by the time he wanted to succeed, he retired. But as a student, I'm so grateful to him today that we could start this program here, and we could conceptualize on the lines that he thought. I also took his inputs, and I took inputs from many others who are here today, and. The whole concept of reimagining intellectual property teaching is also because of current gaps in education, particularly intellectual property education in India. One of the constraints of teaching, just teaching a LLB program, is that we do it as a survey paper. And as a survey paper, you can just do, for example, as a law school curriculum, you can just do the cases, that is a case law approach, and finish it then and there, because you have to wind it up in 40 or 45 classes. And the subject being as technical as it is and as interesting as it is, sometimes it's also difficult to cover all areas of intellectual property law, particularly when there are very, very contemporary issues and contemporary litigation, particularly in emerging technologies, etc. So a full-time course, and a course that is devoted based on contemporary nature of the topics, based on understanding the gaps between what is taught and what is practiced, also based on our understanding of what are the current constraints in among intellectual property lawyers and non-lawyers, and why they are not being able to not just fraternize, but also to speak at a level where each one understands the other language. And that's why we thought this kind of rethinking on intellectual property to make it multidisciplinary would be one of the focuses of the program. The second point is that we also thought that the current teaching method, wherein we have our permanent faculty in the university, and even if you appoint more permanent faculties, the kind of what do you call exposure students need is often not, it cannot be completely coming from the academic world alone. Academic world is usually is in an Eiffel Tower. It's in a very different realm. So we thought to bridge that, we need to have a pedagogical tool that converts it into what is called as block teaching, wherein few people can come and teach. Of course, as per a lesson plan and as per their convenience, we are going to do three months in advance at least, inform people when they are supposed to come and teach, of course based on their dates, and do it as a block teaching method. Conventionally, block teaching method has not been in practice in India, and I don't know of many law schools doing this. I think management schools do it, but not law schools. Law schools usually have semester long courses. So as you can see from the program, these are not going to be semester long courses, but these are going to be just courses that are going to be taught for 15 days, 20 days max, and then we are done. And within that time, to include all kinds of people, both from practice, profession, from the industry, from TTOs, etc. And to do this is going to be a humongous task, but we are well ahead with the schedule and a plan. The third important point that I wanted to emphasize why we wanted to reimagine intellectual property teaching in India is also because of the constraints that current intellectual property teaching has in terms of lack of clinical courses. IP clinics are offered in very few universities. I can acknowledge Delhi University has an IP clinic that has been started. Professor Sival here is associated with the clinic from what I know. One of the things is skills-based courses and clinic courses are going to be part of this initiative. And we want that hands-on training in terms of how applications are filed, how, what do you call, if it's a litigation clinic, then how actually arguing counsels, conceive arguments, how they operate. Of course, that is a kind of a hands-on training, and there is tacit knowledge that is going to be conveyed. So that is one of the other highlights of the course. So why then we have a panel? Because there are some, kind of impending issues when we go through the program in the next few months. When the applications are on, we would also like to work on a curriculum and take further inputs and see how we can build that nuance. And that's why we are having this panel, so that we can collectively think, and I can see the who's who of IP world here today. We can collectively think about education and IP education in particular, along with the panelists. And when the floor is open for discussion, we'll also have suggestions from you as to what can be done. So the idea of the panel today is to have an innovation economist, Professor Suma Atrai from Indian Institute of Technology. She's with the School of Public Policy. Then Professor Dr. Raman Mittal, who has been in intellectual property academia with the Delhi University for at least 2.5 decades now. Approximately. Visiting Professor Jayashree Vatal. She is part of NLU Delhi as a visiting professor, and we both teach a course together on international IP. And she has, expertise in teaching in India and also abroad with Georgetown University. And then Dr. Sri Adarsh Ramanujan. Oh, you'll take the doctor. He already has a very important treatise on patent law. So I would confer the doctorship on him, honorary doctorship on him, through NLU Delhi. Thank you. Thank you, Adarsh, for joining. I don't need to read out their long bios, but they are very, very accomplished people. I can tell you about Professor Suma Atrai itself. That before joining IIT, she was with the business school at Essex for many years. She has worked with the Exeter or Essex? Essex, right? Sussex. Essex. Yeah. And she was, she has worked with the WIPO. She has written on economics of innovation, intellectual property, and we look forward to her teaching in our program. We are planning some collaborations, etc., through their IIT departments. In fact, I just wanted to mention that IIT Delhi and NLU Delhi has a research collaboration partnership. We have signed it a couple of years back. So one of my former colleagues, Arul, he worked on a project on algorithmic bias. Yeah. So we already have collaborations, but she's new to IIT. It's just been a year or a couple of years. So thank you, Professor Suma, for joining in today. Dr. Raman Mittal, as you may know, he has taught intellectual property, particularly copyright law. His book on copyright licensing. He recently also visited Oxford University as a visiting scholar, and we are very grateful to him. And he has been our guiding spirit at NLU Delhi. We usually, whenever we are in difficulty in terms of interviews, whatnot. I mean, I have disturbed him for many, many years now to help us in, shaping our work at NLU Delhi. And thank you, Professor Mittal, for being here with us. Madam Jayashree Vatal, she has worked with the WTO as a senior counselor for around 2 decades. And before that, she worked, she's an Indian administrative law of administrative service officer. She worked with the government for many years. She was India's negotiator for the TRIPS agreement, that is the WTO agreement on trade-related intellectual property rights, aspects of intellectual property rights. And what is important and unique about Jayashree Madam's work is that she is also very well published. The kind of phenomenal articles, peer-reviewed articles, books. One of the first books on TRIPS and developing countries published by OUP was by her. And I, as a student, remember having, glanced at the pages to read. And at that time, it was so confusing. She was arguing new uses are not part of 27.1 and all. And I remember that discussion during those early days of 2000s when the book was very fresh. Thank you, ma'am, for joining us. But what is also important is my association with her for the last 10 years? More.
Because I was an intern and a consultant with the South Center in Geneva. That's when I struck gold, and after that we have been in touch. We have been teaching together in this regional RTPC courses of the World Trade Organization. I as a consultant, and she of course as a staff of the WTO previously, and then we have been teaching in different places. Including this is the second round of course that we have launched at NLU Delhi, and this time it has been open to outsiders. We have some fantastic bunch of 15 students. Or someone sitting in Paris, someone in Washington DC. Of course, they are Indians. They know about the work of Jayashree ma'am, and they know about NLU Delhi and us, and have picked the course. Uh, and it is being successfully run, and I thank you for that, Madam Vatal. And then finally, Adarsh. Adarsh is a very dear friend. He has been a serious practitioner of IP. His seriousness is reflective not only in his arguments as a counsel, but also in his book. And Adarsh has been associated not just with NLU Delhi previously as an adjunct faculty because he took many classes on patent law. He did a seminar course on patent law, but then he had to go to Geneva, and then after that, COVID happened. And then we are now the only opportunity now to see him is through the WIPO program. So, welcome Adarsh to the NLUD faculty board again as an adjunct, as a guest faculty. One of the things that is unique about Adarsh is he's one of the few practitioners in India who have done intellectual property law not just from a domestic perspective, also he has written on international IP and also practiced WTO law in Geneva. Because that's when Lakshmi Kumar and Sridharan opened up their branch in London, in Geneva, and he and his colleague Atul, they started the work there, and his expertise, because he also on my request sometimes also advises our moot court teams. And that is a kind of organic interaction, Adarsh has with the academia. He's one of the few lawyers with an academic mind, and also previously, he's a graduate of NLU Jodhpur. I know him from my Jodhpur days. Long association, Adarsh. Thank you all for joining in today. So before we begin, I would request some felicitations. Please that you have come here, you are spending your important, valuable time with us. As a mark of our token of gratitude and appreciation, we would like to hand over bouquets and mementos. Please. Yeah, we can keep it aside. Adarsh? Surveen, can we take it back so that the view is clear? So, with those introduction, we can start with the panel discussion. So, I have the format of the panel is that we are going to have rounds of questions, and these are designed based on their backgrounds, especially in their existing contributions. So, we have at least a couple of rounds of questions and or maximum 3 rounds, and then we'll open it up for floor discussion to gather your views. I would first like to start with Professor Suma Atrai. Professor Suma, what do you think is the value of interdisciplinary or multidisciplinary learning of IP, particularly in the context of intellectual property and innovation economics? Because you have a background in economics, and we thought that your input specifically in our program on innovation economics and business models would be very useful. But is the study of innovation economics or IP management central to the study of IP today? That is one. Second is if because of your background in the business school in the UK and now with the School of Public Policy at IIT Delhi, is there any resistance to learning IP in a non-law setting, since many concerns are sometimes legal, rather than purely economic, because the law is structured and the economic bargain has been stuck? How do you balance such concerns on the need for clarity as to how the IP legal regime actually operates and is structured?
Thank you. So I'm aware that I'm the only non-lawyer in the panel. So I feel I have to speak for.
Yeah.
You're also okay. But okay. So I wasn't sure about that. Okay, apologies. But I think in IP studies, as in other areas involving innovation economics, um, you always gain from interdisciplinary study because that helps you not to miss the wood for the trees. So very often when we are looking at the practice of one thing alone, let's say economics or management, we miss the other things around because that's the way our pedagogy is always structured, right? So we want to teach based on, if I'm talking about economics, I would teach something like IP based on theories of monopoly because those are the concerns of economists. Or I talk about the profitability of firms or something like this. But the problem in this is that actually when you're actively involved in the world of innovation, one set of skills is always enhanced by another. So let me explain what I mean by this. So your drafting of a patent application is always going to be better if you also understood the business model of the firm, if you understood what can or cannot be enforced, what strategies might work if there was no enforcement. And there is, I mean, I don't think any practitioner has any doubt that this is the case. However, I mean, let's take a few other examples. I am an economist by training, so I think, well, IP is such an amazing institution, but how can I make IP work in the interests of not big firms, but other people? So can a poor artisan in my country earn because of their creativity? Because creativity is randomly distributed, wealth is not. So, can we make the system more democratic? So, this is a question which I, as an economist, have, but I don't know what is the legal point of view on this. And one can, I can go on. I can talk about other regulators can also gain by thinking about legislation in the context that it cannot be fully enforced. So what sort of legislation should I build if I know that there are problems in certain areas? So I think interdisciplinary teaching has always been recognized for this value that it brings to your overall understanding. But it's also the case that interdisciplinary teaching is difficult because, as you yourself alluded, we are used to the silos. Our pedagogy has developed in this way. So there's no lack of interest. I mean, everybody I talk to about IP or innovation wants to know. The students are thirsty for this knowledge. But at the end of the day, they're still thinking about, what profession am I going to join? Am I really going to be an economist? Am I going to be a lawyer? Am I going to join a firm as a management consultant? And these concerns cannot be overcome by interest alone. So this is I think the challenge. I mean, the promise of interdisciplinary teaching is that it offers us this mix and better understanding, seeing the wood and the trees. But the challenge is that we are still operating in a world where there are professional silos and students spend a lot of money on education and they do want to enter into one of those silos, and we cannot ignore that. So that's my first thought on innovation economics and IP. And I also want to not be negative about this, but though this is difficult, it's not impossible, but I think it does need a new kind of pedagogy. It is, it is a possibility to catch interest when they are young. So masters seems to be the right level to pitch this kind of learning. Students have learned to think in one way, and you can mold that thinking to encompass different ways of thinking about innovation or IP.
A second possibility is, of course, continuing education, which in India is sadly not, despite NEP and generations of people wanting to do this, is sadly not yet a reality. We still think about continuing learning as part-time, which in university structures is simply half full-time, which completely ignores the fact that, working professionals come with different skill sets. They have different knowledge needs. So they know some things already, maybe better than us, but they need to be taught some other things, and they need a different form of assessment. Everybody doesn't want to write essays, and we are very bad at that. So we can do it, but we really have to. And as this is a discussion on pedagogy, I'm just sharing some of those thoughts. Thank you.
Wonderful. Thank you. Thank you, Professor Suma. Well, one of the things that we find, in the legal academia is that intellectual property teaching, as core as it may sound in the LLB curriculum, is still not a mandatory course as per the Bar Council of India. And that's very striking, right? But it's not that law schools don't, teach intellectual property. All kinds of colleges teach intellectual property. But the strength of certain courses as compulsory, has a different charm in the sense that sometimes, universities then emphasize on having good faculty on board to teach those core courses, etc. And intellectual property, in that sense, in a situation where it is not compulsory, can get relegated to a sphere of something, which happens in university regularly. Is it's an elite kind of a, what do you call, subject, and it's not public law. Although I consider it's a mix and match of public law and private law. There is a big contestation on whether intellectual property is private law purely or public law. But then there are these constraints. So within these constraints, Professor Mittal, considering you have taught intellectual property at Delhi University for many years now, and that the Bar Council does not mandate it as a compulsory paper, how do you overall see, because you have seen many years way ahead than me, how do you see the overall evolution of intellectual property teaching? I am sure that the first generation was the Professor N.S. Gopalakrishnan generation in the 1990s and early 2000s. But then since then, there have been, particularly within the academia, Professor Bashir's contribution are phenomenal. Late Professor Bashir, we should remember him today. And what do you see as the general evolution of intellectual property teaching within the legal academy?
Okay, thank you so much, Yogesh. Now, a long time ago, when I used to be a student in Punjab University, intellectual property was not offered in LLB as a subject. And since then, we have come a long way. And I'll give you some statistics. We have intellectual property divided into two papers now at Delhi University, which is a 3-year course, one in the 4th semester and the second in the 5th semester. And I'm giving you the statistics for the year 2024, the latest. In the 4th semester, there were as many as 917 students enrolled total. Can you guess how many would have opted for? And they have to choose 2 optional papers out of 13 we offer to choose out of. So how many would have chosen intellectual property out of 917? Out of 917, 863 chose intellectual property. That is 94%. Right? And the choices I just want to cite because it will give you a perspective. The choices, the 13 choices all are gender justice, international institutions, competition law, legislative drafting, humanitarian and refugee law, information technology law, jurisprudence in the second part, criminology, international trade law, rent control and slum clearance, and business regulations. So these are all subjects which are vying for our attention, for the attention of the prospective or the present student. So I think making a subject mandatory does not necessarily enhance its status. Because LLB, the word 2L, why, from where we have got these two words? LLB, we say. So historically, like we say MBBS, it's Bachelor of Medicine and Bachelor of Surgery. So you do 2 bachelors at the same time. Historically, LLBs Why LLB? Why not LB just? Why it's Bachelor of Laws today? So historically, law was divided into two parts. The earliest division of law was civil and criminal. So we still carry it in our court structure, in our studies, in our law schools, even in the name of the degree. LLB stands for Bachelor of Civil Law and Bachelor of Criminal Law, which was shortened to be, as time went by, Bachelor of Laws. So, as you mentioned, the mandatory papers by Bar Council, they are few. They need to be few. We need not make all the papers mandatory. The world is full of choices now. We've just seen how many papers are. This is not the complete list. If you see Bar Council's regulation, I mean, there are scores and scores of optional papers that are offered and new options with newer areas, with interdisciplinary approaches, they are coming up. So I think I would like to go by the Bar Council's approach that yes, let it be an optional paper, and we have seen the statistics. And if it's worthwhile, it will be chosen by the students. And why students choose it? Let's go into it. Because let's go into the psyche of the student. A student is a 20 or 18-year-old student who wants who needs an employment after a few years, first and foremost. So in Indian settings. So we see today, if we see, I have seen the syllabus of Judicial Service of Delhi Judicial Service. Now, intellectual property is a part of that, is a paper in that, is a course which is mandated in that. So I've not seen, because judicial service in India is organized at the state level, not at the national level. So I didn't have a chance to look into the syllabus of other states, but Delhi, yes, we have. So, and a lot of students who are doing LLB, they are interested in becoming judges in the courts. So, I mean, for them, it is important. And then you see civil services in the law optional, there is a mention of intellectual property. So a lot of students, especially from the university from where I come, Delhi University, they are interested in joining the civil service of India or the judicial service. So they are tempted to take up this subject because they'll enhance their understanding and they hope to do well with that understanding in their competitive exams. And then, of course, for lawyering, you can tell better it's important. And for corporate, especially, it's important. So that's the reason why we see a large number of students opting for an optional paper. And if we go by averages, then this belies logic, 94%, and choosing out of so many choices. So I think that puts it in the perspective, and I feel intellectual property as a subject is doing well.
That's actually, yeah, that's amazing. Those statistics really speak for themselves. Of course, how big is the intellectual property market, legal market, is one good question to ask, because it's increasingly getting so niche that even academics are now finding it difficult. There's a case, important landmark case every other day, right? You can see it particularly from the Delhi bench and the Madras High Court that there are like phenomenal, what do you call, developments in the law itself of intellectual property. And as it is, the acts are a landmine for litigation. I think that's where the focus of the students is, that there is going to be a big, IP market in the future. Thank you, Professor Mittal, for those remarks. Now, I would like to move on to Madam Jayashree Vatal. Now, you have a background in international IP, right? So, and you have taught at Georgetown, you have taught at NLU Delhi, and now within the academic community, international IP, WTO law, the WIPO agreements are considered kind of esoteric, in the sense that we don't really know whether these are going to be really useful in terms of our IP, what do you call, practice. But what is also important to notice in the recent years is, it has happened in India particularly, that in many of these IP cases, the TRIPS agreement is lifted on and on by arguing counsel, saying, this is how, it is there in the TRIPS agreement. Pointing figures. This is what the TRIPS says. So what do you think, is how has international IP emerged as a field by itself in the recent years? Particularly since there is a retreat in globalization, but India is still signing, FTAs and IP chapters in FTAs. It's becoming more and more important now. Do you think there is a real world value in, teaching and learning international IP in contemporary times? And also, tell us a little more about what are the things that you have noticed in IP teaching, international IP teaching.
Thanks, Yogesh. Great questions. in my view, it's necessary for students located in India to be taught Indian IP laws, but in the context of the international frameworks, because that context is very important. And that discourse, which is happening at the international level, the current international discourse, keeping up with it is also very important to understand the Indian context. And this business of, whatever Suma would like to call it, deglobalization, globalization, friendshoring. There are a lot of names for this slowing down of globalization, or this inward looking policies that practically all major economies around the world are now interested in. Even in this context, I think IP is going to remain important. I mean, just think about it. The Paris Convention dates back to the end of the 19th century, and it has remained relevant till today. So it's going to be some centuries before TRIPS gets irrelevant or international IP gets irrelevant, really. I mean, there are some core obligations in international law, which all countries have to have, and that context is very important. And before I go on to your other question, I'd like to actually endorse what Suma said about the interdisciplinary approach. I think it's very important. Now, and Suma was surprised also, that I have an education in both economics and law. And I mean, I can't say I'm an expert like her. I mean, I don't have a PhD in either discipline. But, for me, I can see sometimes, especially in the early days, when TRIPS was out, how economists who were very keen to get into this area were making very basic mistakes on the legal aspects of the TRIPS agreement. Today they are much more knowledgeable, but I'm saying in the initial days, which made their policy recommendations really suspect, because they didn't. And similarly, lawyers who at the drop of a hat would want to make economic analysis without much background. I saw it both ways, So I think a student who has a good and correct appreciation of both the underlying economic principles as well as the legal principles would do a much better job, whether it's in courts of law or in the academic profession or in businesses or anywhere. I think both the international aspect and the interdisciplinary aspect is something that we need, and that's very good. This LL.M that NLU Delhi and WIPO are doing will bring that out, which I'm very happy about. The other thing I wanted to tell you is, maybe I should leave it for another question, or should I? Because I wanted to, this is not your question, but I wanted to, talk about the TRIPS negotiations in a certain sense, the negotiating background, how it is important. Just like it is important to know why a particular provision of the Indian IP law came in, why did it come in, what is the background? It's also important to know why certain international provisions came in, what is the background, how did it come in, what do these words mean? So you could really go completely wrong in understanding your obligations if you didn't understand that.
Yeah, I think you should tell us a little more about it, because I know for sure, because I co-teach with her. She knows which country put in that particular word in the TRIPS agreement, a single word. So you can go on, please.
Yeah. So, I mean, this is why, we didn't want this knowledge, because unlike the WIPO, the World Intellectual Property Organization, WTO has no record of the negotiations. So therefore, there's no way you can know this. That is why when I was on the staff of the WTO, I got whoever was alive, the TRIPS negotiators. Many had passed on. So whoever was left and whoever was willing to come, we got them to write a book, to write chapters in a book, which I call The Making of the TRIPS Agreement, which is available for free. It was published by the WTO. It's available for free online, in which I have a chapter also called Patents, the Indian Perspective. So it's important to know where India was coming from in these negotiations. So that you can get, all students of IP can get for free now. And then last but not least, I'd like to say that on pedagogy, because Suma already touched on pedagogy and you asked the question also, I think learning by doing. There is no other way.
So Yogesh very brilliantly thought of this in the course that we are teaching, that is International IP Law at NLU Delhi. He conceived of this pedagogy where we would do not only MCQs, that is multiple choice questions, every week, but we would also do group exercises where we would set problems and divide the class into groups and ask them to work on these problems, which were taught in the previous week. Now, this takes a lot of effort. I mean, despite the fact that we have brilliant teaching assistants, one of whom is here, Kushi, but despite that, it takes a lot of effort, and we may not always get it right. But I think, as some of the students have told me, this is the best way of learning. So there's no other way except learning by doing case studies, group discussions, MCQs, this kind of thing to reinforce what they have. Otherwise, if we are just lecturing them, however much we are open to they're asking questions and all, they will never get it unless they think about it themselves. So I'll stop there. Yeah.
Wonderful. Thank you. Thank you, Madam Jayshree. Now moving on to Adarsh. Naturally, the question to Adarsh is going to be on he comes from a different background, but he has an academic mind, as I mentioned. What are the current gaps in the learning of IP law that in the academia vis-a-vis the requirement of practice in general and particularly, IP prosecution or transactional IP, particularly IP litigation, since you are been a litigator
Yes.
for long?
Thank you, Yogesh.
Yeah.
It's an honor to be on this panel. I mean, I think I'm a bacha in front of all these people. Even though I come from a family, I'm a first generation lawyer. I come from a family where I'm surrounded by people of science. So I do have a science background in law, multidisciplinary there. It's the training of the mind that counts. The training of the mind could be in economics, it could be in science, it could be in humanities. But the training of the mind in a subject other than law has a fundamental effect on how you view a provision of law. And ultimately, I'm a loyalist. I'm a loyalist to the law. I'm not a loyalist to a particular school of thought. I'm a loyalist to the law as it is, right? So when I informed my dad that I'm going to do law as a school kid, he only had one piece of advice to me: you do whatever you want. But he's an electrical engineer by training from IIT Madras. So he only gave me one life lesson that I should follow. That if you take the X and Y graph, time versus knowledge, so time on the x-axis and knowledge on the y-axis, the day the slope of the curve is 0, that is your curve flattens, you should stop whatever you're doing and retire. Right? Your curve always has to be straight up. Your angle should be 45 degrees, always learning. So the day you stop becoming a student of whatever profession you've chosen, stop doing it and move on. So I originally came from a very, very purist school of thought. I call it the purist school of thought. That is knowledge as an end in itself. There is, of course, the other school of thought, and it has a huge relevance to what we are discussing, because your question to me was gaps between academics and practice. And my overall view is some gaps are good, some gaps are bad. And I think it's important for our pedagogy and our curriculum to realize what gaps are good and what gaps are bad. So the purest school of thought is knowledge as an end in itself. You are not influenced by the happenings in the economy. You kind of have that idealistic view, sit in that ivory tower. The pragmatist view, what Professor Mittal was saying, that ultimately I come to college because I want to be educated and I need a job. That's the reality of the world, right? I feel today, in today's world, a good education, at least at a higher level, must be at that junction point where you retain your purism and yet you maintain some level of practicality. The day academia becomes fully practical, I think we've lost the education system. And the day practitioners become fully academic, the legal system will fall. I think that balance, that intersection between being a purist and a pragmatist is very, very key. And that takes me to the second point in terms of identifying what are good gaps and bad gaps. Good gaps, rather bad gaps, I should start with the negative and then end with the positive. I think what we feel at a practitioner's level is students coming out of law schools, whether it be at an LLM degree or at an LLB degree, what we're looking at are students who will have strong foundations. As a practitioner, if I have to recruit a fresher, and as a counselor now, I do recruit freshers now and then, but when I was back in the firm with Mr. Lakshmi Kumaran, we used to recruit a lot of freshers just out of law school. Our scope and discussion with that student is not going to be explain to me this advanced concept in patent law or plant variety law or GI law. No, we are looking at students who will have strong foundational ideas, understand how the legal system works, at least in principle. What are the general do's and don'ts in law? Conceptually, how do you understand consent? Conceptually, how do you understand exclusivity? How do you differentiate exclusivity from monopoly? They're not the same. The economists here will vouch for that. You don't have to take my word. But it is these foundational concepts that we expect students to have, right? Because the rest of it, we can teach you in practice. How do you operate in court? How do you prepare for a case? Now, it is true that our generation of lawyers who are recruiting from law school, we have become a little lazy. And that's the reality. The kind of mentoring that I used to get from my seniors when I joined the profession is very different from the kind of mentoring we are now giving. That's the reality. I'm not saying it's good or bad. That's the reality of the market today. So there is a slight push now that the student who's coming out of that law school, beyond that foundation, I want that incremental value, because the time that we spend with our juniors is actually reducing. That's the reality that I've seen in practice. The volumes have gone up, competitiveness has gone up. So we are expecting students to have that little delta over and above that foundation. And that is something an LLM degree can contribute significantly, right? That takes to my second point, which is what is the good gap that I see. The good gap that I see, and I've realized it, and I used to realize it a lot when I was regularly teaching. Now that it's been a while since I've been regularly teaching, but I had this epiphany when I was writing my book. I realized that as a practitioner, sometimes we get caught up in rhetoric, because you tend to do a certain type of cases all the time, this way or that way, and it ends up training your mind in a particular direction, whether you like it or not, unconsciously. Going back to academics and even writing a paper for that matter, it's a refreshing change, because it forces you to sit down and think about what you're doing, not just doing it. And sometimes having that piece which is separate from the daily rigmarole of practice, you end up realizing that what we're doing in court sometimes is actually not correct in the long term. To have that balance is where academics come in, because whether we like it or not, academics do sit in a little bit of an ivory tower, and I think that's a good thing, because you have that ability, the time, the patience to actually think over meta concepts, rise above the daily rigmarole, and kind of position, take a view or a position or influence thinking at a policy level, that this direction that the practice is heading towards is perhaps not the right perspective to have. We need to push back. I'll give you a classic example. Today, we've been talking about responsible IP from our chief guest statement. We've talked about the practicalities of intellectual property practice. And you'll see the emphasis here of how IP is not a system unto itself. IP is a system that is intended to contribute to the growth of a country. But look at the views on growth of a country, right? One school of thought when it comes to growth of a country is that reduced focus on IP, increased focus on copying of IP, because that leads to more spread. But the exact opposite school of thought will be, unless you push for more IP, stronger protection, you are not going to have that fundamental growth in science and fundamental growth in national economy. So you still have two schools of thought for the same policy objective. And as practitioners on a day-to-day basis in court, we sometimes forget that it is beyond just that system. There is something there is something behind it. And the academics are the ones, in my opinion, that bring that focus back. So some gap, in my opinion, some buffer needs to be always kept between academia and practitioners. Yet, courses like the current LLM that you're having, which is about applied law, that is going to make a big difference, because people like me back in the day, we went abroad because we wanted applied law after our LLB. We wanted applied law before we went into a firm or went into practice. So we went abroad. If you are able to bring that applied law concept into Indian academia at an LLM level, I think that will be a fantastic shift in how IP practitioners view academia also.
Wonderful. Thank you for those brilliant remarks. You know, as I had mentioned, that he has the ability to think about, you know, not just what the litigation field thinks, but also what the academia must do. But I think he's absolutely right, because if everything becomes the same, then you know there is no way to, you know, look back, and there is no way actually to think forward. I think thinking forward and back has to be a constant process, and that balance has to be stuck. And I'm thankful for those comments, Adarsh. Uh, the I will again start with round two with Professor Suma. Professor Suma, one of the things that we understand, you know, usually in the academia, we dabble, you know, in the empirical aspects of IP. We read a lot of these papers. Of course, legal academicians cannot be, you know, very serious scholars of empirics from the economics perspective, but we do dabble into these fields. Should we go empirical in IP teaching? And because I genuinely see that there are certain limits on learning IP from an empirical perspective. For example, uh, the question of whether or not IP promotes innovation, because if you're contributing to policy, you will be frequently asked, what is the value of what you're suggesting? Because this may have certain kinds of consequences as to how innovation is structured or how access regimes are structured, etc. So should we now integrate empiricism in IP teaching? And what is your thinking on that?
Thank you for asking me this question. So, one of the things that has often frustrated me is that, lawyers who are very clever minds will not look beyond a particular case. It's really quite, and you think about the spectrum of issues around or cases around a particular topic.
We call it professional ethics.
So you look at the spectrum of cases on a particular topic, then, like all distributions, this has a tail and a center. And it seems to me that the emphasis is perpetually on the tails, right? Because the precedent, the exception, these are all like terminologies that are saying, look at the specifics. But there is something to be gained. Again, I'll say the trees in the wood here, because we also want to know what's happening on average, and that's where the empirical training is handy. So you have to think about, I mean, at least maybe this is my particular thing, but whenever I look at something, I always ask myself, how typical is this? Is this happening like 6 times out of 10? Is it happening 1 time out of 10? And maybe, my attention is drawn to the 6 times out of 10, unless there's a compelling reason to look at the 1 out of 10. Mm-hmm. So to have that discrimination, you actually need to understand things empirically. I don't know what other word to use. Probabilistically could be another, but
statistically.
Yeah. So I think it's a really important training, and as I said, because IP is 60% lawyers and 40% other disciplines. I've had the opportunity to meet some amazing analytical minds, but they will not go beyond the case. And this insistence that everything is specific is also somehow theory free. If you think about it, we can't generalize them. Right? This is what this is also a complaint against historians, by the way, because every time you try to say something general, the historian will find you an example which is not. And then it's sort of, I don't know. I think if you think those general views of the world are important, then I think we must have some empirics. if you think, well, like historians do, that no case, history repeats itself first as farce and then as tragedy. If you have that kind of view, then of course that's a view of the world.
Hmm.
No, so
Yeah, lawyers tend to take a easy way out on the economics of IP. So the way we think is, intellectual property is one of the instruments. Whether innovation happens, does not happen, it's a problem of the ecosystem. And if there is a problem in the ecosystem, then you institute subsidies, you have government R&D, you have prize funds, whatnot. You have alternatives to IP. But for IP practitioners and IP academics, IP still remains the core. That whatever happens to the world, okay, we are fine. We will try and find a legal solution to our social problems. So that's, I think, there is some kind of inherent, what do you call, limitation that we as lawyers have, and I agree.
Can I comment on that?
Absolutely, absolutely.
Because if you think about some of the SDGs, which are so much in focus now, especially I want to think about two: access to health and access to medicines and access to climate change technologies. This attitude is not going to help.
Absolutely.
Right? Because the people who need the technology are not, I mean, there are ethical reasons to object to it, there are practical reasons, because what's the point of having the perfect patent if nobody's using it? Right? So somehow I think IP law has to take cognizance of all that, and it can't do that unless you can say that, well, look, medicine is different from I don't know, electronic devices. But how are we going to say that without any statistics? I'm not sure. So maybe this is a limitation in my thinking, but that's how I see it. And I'm really happy that you asked me this because of pet peeve.
Okay, I think we'll get to hear a little more on that, when we ask Madam Vatal. But I wanted to quickly move on to Professor Aman Mittal. Professor Mittal, in the legal academia, there are pedagogical tools that we, use. We have case studies, we have group exercises, whatever. I think Jayashree Madam emphasized on what we do. But you are a poet yourself, right? So you have recently published The Rhythm of Law. So do you use poetry in intellectual property teaching? Because you have written, there are also, couplets I've seen on copyright and, other aspects. So what kind of innovation do you think, should we, introduce in the academia, legal or otherwise, to make IP teaching, it's contemporary. Everything is tech, everything is photographs, everything is, AI, everything is there in IP. But how do you make it more fun?
I think we follow the traditional method of reading from the legislation and from the decided cases. And personally, I feel that the cases that are decided that take you to the real world. For example, if you go back, 1941, it was decided by the Privy Council, Francis Day and Hunter versus 20th Century Fox. Now, this is in those days there was a musical composition by the name of, and the title of that composition and song was "The Man Who Broke the Bank in Monte Carlo." And the same song was then adopted by 20th Century Fox as the title of the film. So when I had to teach that course, because you asked the question that how do we approach it, how personally I feel it, that I just took those. These are available from the internet. So I just copied them on my mobile phone and just played in the class. At least you can do the song. The film is long, but then they will understand. I encourage them to watch the film also. So and
use.
yeah, of course.
They fought the case, by the way.
Yeah. So and then you see, if you see Najma Heptullah versus Orient Longman, the whole case was fought for those 30 pages. Now, what were those 30 pages? Must it remain a mystery for lawyers, for law students? So I encourage them to find out, to read I got the book in the library and find that, okay, read those 30 pages. At least go through those. Why they were hidden from the country for 30 years. And after those 30 years, why there was a lawsuit on that, which was ultimately decided by the Delhi High Court. When we say another example is R.J. Anand versus Deluxe Films. Now, this is a case which was, 1978. It was decided by the Supreme Court of India. Now, inside the case, when you read the case, what is mentioned is that at that time there was no mobile phone. There was, I think, television was also not there in 1978. So, a special screening of the film was organized for the judges of the Supreme Court of India, and so that they could go and it might have gone with their families and all enjoy it. But apart from law, uh, legal angle, so I think it's very important if we are teaching copyright law, we should have a repository of all those materials ready with us to be shared with students. And I think your specialized master's program can very well start with that repository.
I wish.
Yeah.
I really
Because like Delhi University, we have one subject or two subjects optional. And how long is a semester? Practically, leave aside the vacation and the examination, it's 4 months. So 4 months, and you have to study 5 subjects. How much time can a student devote to one subject? So it's a few days. But and then in those few days, we cannot expect them to go through all those materials and do that in-depth research. So I think this master's program can definitely have that repository of all, not just from copyright, but from all the areas that you are concerned with. That'll be a welcome addition to the IP scholarship of the country as well.
But have you used poetry as a method?
Uh,
No, I'm
Well-
going to push you a little bit on that.
okay, so let me, if you permit me, let me say if it makes sense. So I knew that you're going to ask it. So permit me if I read one, right? So does it make sense? Because I didn't know. It was not planned, and it just came by, you know. So let me choose one. Which one? An old one that I wrote or a recent one? An old one.
Which has on concepts of.
So the one which I wrote long back was The Delicate Balance. And may I?
Yeah, please,
Yes,
please.
Man was a hunter, and when he started to gather, law and property were then born together. When was it? It's not in my memory's leather. We know it riding only on imagination's feather, so reimagining. When things were available in nature for free, they then belonged to the marauder's spree. To avoid the disputes being decided by blood, the norm of ownership sprouted like a little bud. From movable to immovable, the bud continued to grow. Things then belonged to the sweat of the brow. Man's labor was a subject then to protect. To own more became a matter of respect. Limited were the things created by labor, but man wanted to own more than his neighbor. Intellectual creations were then added to the list. Man then wanted to capture whole world in his fist. When exclusive was the genre of all his right, drunk he became with the wine of his might. Bothered he was not about the people's plight, who would then give the mighty a fight? To transmute to order from such a chaos, public interest soon came across. The one is still permitted to own, but of sharing you cannot now be shorn. As the people's lawyer laid bare this plea, it were the masses who shouted out with glee. But wait, are we not approaching the same old spree, where things were set just for free? Public interest came as a gift to wonder, but even this can verily become a blunder. Is it in man's destiny to go round and continue eternally with the same old wound? Owning and sharing must go hand in hand for expression, for invention, and also for that famous brand. Striking this balance is like playing with glass. Delicate it remains even for the men of class. So that's it. I rarely use my own poetry in classes because it looks like, you know, you're advertising, though I used it today. So sorry for that. But I think it is meaningful if you're teaching, especially copyright. We can make use of those.
Yeah,
And
because I know of people who have Sean Flynn, for example.
Yeah.
He uses he asks students to go and take pictures and then ask them to share widely, and then suddenly he comes up with copyright questions. How did you share? Whose permission? Whose ownership? Who is the author? All those kind of questions, deeper questions you ask in the class, and then I think that creates. Yeah, please go ahead.
Yeah, and exactly. I was once in a class in United States of America. The program there, you asked me to go,
Yeah.
And there, the teacher teaching copyright, he came up with his guitar and he played something, and then he played the copy of it and asked the students to judge whether it's a copy. So it gives a new flavor.
Yes.
And that is introducing some sort of practicality. Otherwise, say what is the definition of musical work, how it is infringed, but how actually it works in practice. So only a musician will be able to tell that.
Yeah.
So I think it is scope for a lot of such experiments.
Wonderful. Wow, that's that. So thank you, Professor Mittal, for reading out the poetry. Wonderful as it is, we have also, I would like to have more poetry being read. I'm so tempted to ask you to read the one on copyright, but please refer to his book, The Rhythm of Law. And we'll go on to the next round of question with Professor Jayashree Vatal. Now, one of the things in international IP is the idea of balance. You yourself have negotiated trips. You know that there is, you were pushing Article 31 for developing countries, etc. In contemporary times, particularly during COVID, there was, the whole COVID waiver debate. Intellectual property was seen, more than necessary evil at this point of time. But we also know that there were other policy issues, and those were not purely related to IP, particularly in relation to production. But as a negotiator and as a teacher, both at Georgetown and in India, uh, do you really emphasize on a lot of policy, because of your economics background, you can also integrate policy very easily, which lawyers often cannot. So how do you view this balance between policy and law, and how do you contextualize what is happening in contemporary debates, and then try and make the students understand what or to differentiate between the wheat and the chaff? How do you do that?
Yeah, thanks, Yogesh. You know, I mean, this is, I think it's very important. And I think it follows from what Raman was also saying about making the class interesting and relevant for the students. So if you kind of talk about contemporary issues, which, people are seeing in newspapers and current debates and so on, then it makes it more interesting. So, a lot of this, in fact, I used to know one professor of intellectual property in Switzerland who would every day come with a newspaper clipping relevant to intellectual property and start with that. Like in today's newspaper, this is what I saw on intellectual property, and let's discuss this. So I think it's very important to keep it, kind of to not make it dry and boring, but to also kind of give it the policy flavor. The other thing you asked me is about the economics. Frankly, because I'm teaching international trade, intellectual property, and public health in Georgetown, and I've also started teaching it now in Bangalore. So what I like doing is I like also doing a very short kind of introduction on the economics of the pharmaceutical sector, for instance. Because economists, if you look at what they have said, they come from this view that, and this is very well based in empirical work and so on, that patents are uniquely important for the pharmaceutical sector. Pharmaceuticals, biotechnology, these sectors, patents are uniquely important. So that this industry depends a lot on patents for its business model as it is today. The business model as it is today, it's different that you can think about alternative business models and so on. But as we know it today, it's really very important for the pharmaceutical industry to have this exclusivity, which comes from patents. And as Adarsh rightly said, exclusivity is not the same as monopoly. So to understand this, to understand why in current, in the current debate, in current negotiations, why is the pharmaceutical industry and the host countries of pharmaceutical companies, why are they so paranoid, I should say, about any weakening of the patent system? It's because this is where they come from. This exclusivity is so important for them. The other thing I would like to say is, we need to understand also the law, what is exactly covered by a patent claim, how much, and there's more and more understanding of this amongst economists now, how there is competition, even on a patented product in the market, there's a lot of competition. So it isn't as if there is, market power just because there is a patent. So these kind of things I think are very important to understand in the context of the access to medicines issues or the access to climate change technologies issues and so on. So the fact that, yes, theoretically we can conceive a different patent length for every sector of industry, theoretically, it shouldn't be one, it shouldn't be 20 years from the date of filing. For all sectors, it should be longer, shorter, you can argue whichever way you want. And maybe some countries do have patent term extension for pharmaceuticals, for instance, and so on. But it's not practical, really, to impose this internationally on all countries around the world, that you will have to now administer a patent system which has so many different layers, for every sector, however justified it may be. So all this theory that economists have thought about, and it's excellent theoretical work on optimal patent length or optimal patent breadth and scope and depth and so on. It doesn't really translate, in my view, to policy. So while we need to look at the empirical aspects of what economists have done, and lawyers are not aware of this, law students hardly ever, come across these economics, these articles which are so relevant. So I like actually to do a little bit of this, just to put it in context for the law course that I'm teaching.
Yeah. So that's the reason I asked, how do you differentiate between the wheat and the chaff? Because see, lawyers often in their writings refer to economics. It's not that it's not referred, but you read only the abstract and you don't understand a word of modeling, econometrics, and you end up reading the conclusions. And sometimes we get it absolutely wrong. And it's very important as lawyers. Frequently I've seen papers, economists writing on law don't cite lawyers, by the way. They don't consider economics by lawyers as very serious affair. But lawyers always tend to cite economists, at least the academic ones. But sometimes lawyers don't get it right, and that's frequently the case that I have seen, because the policy sometimes is so loaded with certain jargons,
and assumptions,
that it is very difficult, sometimes for many reasons, and sometimes even including ideological reasons. And we should not stray away from this question of how much ideology dictates what policy you talk about. And that is a problem, and remains to be a continuing problem, and we need to find the right balance with right set of readings, etc. Moving on from that, thank you, Jayesh madam, for that. With Adarsh, you said your BSc LLB degree was quite helpful to you, not helpful to you, because NLU Jodhpur did this experiment. I don't know whether they continue to do. They stopped it. Yeah, they stopped it. That's what I heard. But unless I don't know, I mean, be aware of the fact. So if I can go with that. How do you think the BSc LLB degree, actually shaped your career in patent law as a patent law litigator? And now that we are starting the course, and because this is going to be the third round, what would be your suggestions? Because we are going to get all kinds of people. There is an entrance test. We are not going to specifically ask that you have to have a BSc. We are going to get some students who have a science background and who may turn up, as good litigators and coming to you for work. But what do we do in a situation where we have a mix of crowd? And what do you think we should? Because now we have seen the course curriculum also. I mean, the broad structure, not the curriculum, but the structure. What would be your suggestions?
So one, right off the bat, the fact that I have a science degree made and continues to make a significant difference to the way in which I can assist the court as an arguing counsel. Our job generally as counsel is always to translate the client's interests within the legal parameters, and at the same time, as an officer of the court, ensure that the judge is not assisted with incorrect facts or incorrect law. And we have a very narrow, limited window to do all of this, because we have a huge pendency and backlog. So to have somebody with the science background, our job is to encapsulate that tech and merge it with law and package it in that short time frame. It takes a lot of prep, particularly in patent matters, and it is not just in patents. You take plant variety law, you take trade secret disputes. I was recently doing a trade secret dispute on algorithms for, how do you structure advertisements? I have absolutely no idea. I'm more specialized in organic chemistry, but the difference is that even if you're only specialized in one field of science, mentally you don't have any blockage to any field of science, right? You are not opposed to looking at data. You're not opposed to looking at paragraphs of material that's got nothing to do with the law. You're used to seeing stuff like this, even if you've trained in one branch of science. Therefore, one is the tangible effect you have in court, because as an attorney with a science background, you certainly come off with much higher credibility to a judge, knowing that what's coming off your mouth is certainly from a trained mind in a field of science. And two, intangible benefit, which is mentally you are not opposed to looking at anything other than law. You can look at anything if you want. And I mean, a lot of discussion now on economics, for instance, is just I'm reminded of Justice Sikri's judgment. It's 2017 Supreme Court, Shiv Shakti Sugars. It's on sugars, it's on sugar licensing and factory law, etc. It's got nothing to do with IP. But there are multiple paragraphs where Justice Sikri specifically emphasizes on how, as judges and as lawyers, we can't sit in our ivory towers. Just look at that strong formulation of that statute in ignorance of everything else, where the statute permits, where the regulation permits, where there is room for interpretation, the economic effect of a decision of the court must be assessed before taking a particular path. It's actually a Supreme Court binding judgment. Under 141, it's binding on all of us, binding on high courts and all district courts. Every interpretation where the room is available, look at the economic effect of your decision. And it makes, and I think there is at least on the tech side, the tech and law side, there is a dearth, I would say. I don't know, maybe I'm in ignorance. But generally, as practitioners, we feel there is dearth of statistical models examining why IP, how IP, where should it end, where should it begin. We actually want statistics like that. And I can tell you, with the increasing number of litigations we see in the intellectual property division, judges also want to understand the impact.
Particularly IP in competition, because you do both.
Yeah. So IP in competition is even more, like Professor Vatal was saying, there is, as a matter of law, there is no assumption that holding a patent by definition amounts, to quote unquote dominance under European and Indian law, or quote unquote a monopolization claim under Sherman Act in the US. There is no such assumption. It is possible that in a particular fact that may be the case or that may not be the case, for which you need to economic evidence. And I can tell you, as a practitioner who's done a little bit of competition law in India, we find it tough to get experts on that subject. Experts who can study a particular product, study that particular product market, study the geographical market for that product market, and examine what is the market, who are the market players, what market percentage do they occupy, how do you decide this market. There is a dearth. The reality is that actually when lawyers want to look for economists, we find it tough to get people who are able to translate that information into a legal framework. So there is a necessity for lawyers and economists also to come together, as much as there's a necessity for lawyers and people with science background to come together. And I must also emphasize that this additional knowledge that you will have, whether it's economics or it's science or any other subject matter, it's not just about patent law or tech law. You look at a typical customs classifications case, right? Depending on which 8-level entry or 10-level entry you fall under, your customs duty will change. And now you've got that imposed in GST also. You've got the same harmonized system of nomenclature in GST also. The difference between a 50%, 15% duty and a 28% duty will simply translate to, as a lawyer, your ability to convince a judge that from a technical standpoint, the product falls here and not here. Without that, either your innate knowledge or training in that field of science, or your innate ability to absorb a subject other than law, is the only one that will assist you before the judge on that date. It's therefore not about the knowledge in the science, it is about your mental training to adapt to a particular subject other than law. That's the key, in my opinion. Doing a course like a BSc automatically, trains your mind to do that. Not doing that course, which is why today you look at it, nobody does a direct LLB from, by definition, nobody does an LLB directly from 12th. Even when you do the integrated 5-year course, it is always matched with a subject before law. And the original sequence always, you finished LLB was a postgrad degree. You have to finish your undergrad and then do LLB, which is still retained abroad. You have to train your mind in a subject other than law, and you have to continuously keep training your mind in a subject other than law. It need not be science. You take even a most esoteric subject like philosophy, it doesn't matter. It's just your mind cannot be trained in that one subject alone. You need to look at other subjects. So I would say the tangible and intangible benefits are far numerous for lawyers to kind of ignore any other subject matter other than law. And I look forward to more empiricism myself as a practitioner. I want more empirical data. I want more statistics to learn and understand. I mean, as practitioners in court, when we inform judges that, for instance, today we discuss a lot on Section 3K of the Patents Act, for instance. There are pending matters even on Section 3I, which is diagnostic methods or business methods or computer programs. You take the US Supreme Court judgment in Bilski. It's a very famous judgment now by which there was a pushback on business method patents in the US. There are sections where you will see amicus curiae have made submissions, and I presume backed by data because we don't have access to what they filed, arguments on why or whether the patent incentive is needed as a matter of policy to incentivize innovation in business methods. And you will actually find a specific ruling or observation from the US Supreme Court saying, well, I actually don't see anything in your material which suggests that you need that incentive to actually innovate in the business method side. It appears that people have been innovating and coming up with new business methods irrespective of the existence of patent protection on it. That's a finding. I'm not saying it's right or wrong, but where permissible, lawyers and judges are more than happy to accommodate that kind of empiricism. The reality, though, is we are unable to bring that into the courtroom. And I think many practitioners, at least the more devout ones, will want that to be brought into the courtroom. So we look forward to that day.
So we rest assured then that this non-law track is going to have a lot of value, because I think there is, as you said, there is a need for experts who understand IP, but who come from their own disciplines, right? And I remember of the situation when the government of India wanted to do a report on the economics of parallel imports. It was so difficult for them initially to find out who would understand exhaustion as a legal concept amongst economists, as a legal concept first, and then try and work out the economics. Thank you, Adarsh, for that. Professor Suma, what would be your suggestions? Maybe in a minute or two we can wind up each one of us. What are your suggestions for the forthcoming program?
Well, I think we have to try and see what works. People here have already said a lot of things. I've also said some in my beginning. So I think that interdisciplinary teaching is different. So doing it right is hard. But if you're led by particular applications, maybe it's a bit easier. So that's what I got out of. And the second thing is that I really care about being able to train people who have worked a while. Maybe, in our country, people start working because of hardship at home and so on. But to give them a chance to, if they're interested in law, to achieve some competence in it without having to give up their job. And I think we are very far on this, and I'm really astounded. We have distance teaching, we have the technology. We are not able to package it because we cannot seem to teach without essays and undergraduates who listen to everything you say. It's as much about our hierarchical thinking as teachers as it is about finding ways to do it, you know.
Yeah,
So-
but that gap, I think this course is also not going to fill because this is a full-time course.
Yeah.
Working professionals would not find it, would find it difficult to actually stay away for 1 year from jobs. And the job market as it is very different now.
Yeah, but it could be the first step to that. But perhaps-
Definitely,
IP office will come, IP office people will come.
IP office is one, we have
TPOs,
TDOs, yes.
It's a big market actually, if
Yeah.
you think about it, yeah.
Professor Mittal, what would be your recommendations?
Uh, a v- I would like to narrate a very short story. It was told by one of the greatest philosophers that India has ever produced. His name is Chiddu Krishnamurti. So he said, I listened to it only on the internet. He said that he was in search of truth. And he searched for truth here, there, and everywhere. So intense was his search that he left no stone unturned. But truth was not visible. It was so difficult. Nobody would give the address of truth. But finally, somehow, he located the address of truth. And he amassed all, it was a long journey to truth. And he amassed all his resources. He sold his belongings because that was his only preoccupation of his life. So he started the long journey. And finally, he reached the house of truth. The nameplate said truth. He entered the house only to find that truth had already vacated it and moved somewhere else. So that symbolizes the importance of imagination. No subject, especially intellectual property law, which is so changing, is so dynamic. We have to continuously imagine and reimagine. So I think this, if I have to leave one word, it's only your word. It's imagining and reimagining. Because imagination once done, how can you transfer imagination? If I imagine something, can I transfer it to you? For you, it won't be imagination. It would be information. It would be something else. So I think if we can make such a course where students are encouraged to imagine on their own, that will be something which is unique and great.
Mittal, what would be
Yeah.
your suggestions?
No, really.
And I'll hold all of you accountable because you're going to teach.
Yeah. No, I was thinking this modular format that you have. I mean, it's very convenient when you have experts coming from all over the world. You give them a module, they finish in 1 week or whatever, 10 days, and then they leave. But when I think about Suma's contribution, for instance, or anybody else who is an economist or a business management expert, I feel that every module should have that component. It's not that you can do law for 10 days, do economics for 10 days, do something else, and then move on. The student has to connect every legal subject that you're teaching has to be connected with the policy, with the business, with the economics of it. All of it should be integrated in every module. How we do that is, of course, very difficult. I understand.
Right.
But at least we should try, to do to some extent, at least from experts who are available in Delhi. We should try and bring them, even if it is for 1 day, one class, things like that, to think about that particular aspect, because lawyers you're going to get for that block, you will get an expert to teach that law, but how to integrate it and how to prepare exercises which are interdisciplinary. I talked about exercises, but those exercises that we do are very simplistic, right?
Yeah,
Depending on-
lawyerish.
Lawyerish, exactly. So how to do interdisciplinary exercise? That's also something we need to think about. Yeah.
Adarsh?
So my suggestion is that I think every paper or course that you're going to have or module, how you want to divide it, should have a mix of a practitioner and a pure academic. Because I think my general message is students should learn practicality, but should know how to rise above the practicality. And for that, I think we need a mixture of a pure academic and an actual practitioner. That's my suggestion.
Thank you. Thank you very much. We'll now open for maybe a couple of questions. Thanks to all the panelists who are here. Any pressing questions? Yes, Professor Lisa. Mike, can you use a mic, please? Is it not working? Just give the. You can.
So,
Professor Lisa Lucas.
myself, Lisa, from Indraprastha University, Delhi. So, this is going to be a comment or an observation what Professor and one question to Madam Jayashree. So, my observation is that you said there were 94% students who opted intellectual property rights when it was offered as an elective. From my experience, I should say that it's because of the teachers. Because a major decision-making factor in every LLB study, when they have to choose an elective, is the capacity and potentiality of the faculty who is teaching. So Professor Mitchell himself is an institution, and DU is blessed with many IPR teachers. So actually, that contributes to that. So if the same survey you do in some other colleges, which is not known for IPR faculty, of course, the result will be totally different. Need to think universities and colleges where an IPR is being offered in LM without being conducted even a single class. Because I have come across some students arguing on whether patent or copyright would be for this particular idea, even after getting an LLM, without realizing ideas neither be patented or copyrighted, because they never interacted more with them, they never sat in. So we have to really think about how we can build a good faculty in colleges wherein the IPR is being offered. Of course, NLUs and the central universities or state universities might be really having a good faculties because they advertise specially for IPR. And wherein teachers never had a formal education IPR, teach IPR, even in LLM. So there the situation is really different. So now my observation. And one question to Jayashree Vatil Madam is, your point on teaching IPR relevant to the student is very well taken, and I think it is very important. So could you please give us from your wherein we can make IPR subject so relevant, apart from referring to contemporary reporting or news events like that? Could you please give us some more inputs on how we can make it so relevant for the students?
But I think for every subject, you will find something contemporary you can discuss. IP is so, it's so interesting, and there's always so many interesting stories which students are aware of. For instance, even on the EFTA, on the recent news reports on EFTA, the India EFTA agreement, you can pick up something from that and see. So, yeah, you just have to use your own imagination.
For example, yesterday I did a class on trade secrets. Yeah, we did a class on trade secrets. And on the Indian side, the most recent thing is the Law Commission report.
Yeah.
So I looked into the Law Commission proposed bill and I told them that what do you think about these provisions when compared to the common law? Well, I had to do the text because of the Delhi High Court panel discussion on Saturday and Sunday. But then I think there is a way to integrate what is contemporary, but there can be limits. Others, you remember I had invited you for my friend. How will I teach introgression and what not in the class? I can't even visualize how you can, and you did the job of having, PPT and slides and everything. I had also got once SNAs for, doing the same thing from the other side, from the other side, of course. We teach both sides. So that is the way to integrate that, particularly, but that would be limited, right?
We face this problem also when we teach economics or certain kinds of management. It can be very dry and too theoretical. And application is, of course, of essence because, the same theory can be modified. So one thing I did, which was very successful, was that I asked, so I think the skill is not only to know how to apply, but also to be able to look at the world with those frames, I think that's a kind of different step, but it's related. So if I see something happening, I should immediately know what framework I have to put on it so that it makes sense. So I asked them to make these little videos. So they had to discuss the topic with me. And of course, I have to confess it was mainly to overcome the challenge of ChatGPT. But I asked them to make this little video that, okay, you learned so many economics concepts. So go and choose a problem and make a 10-minute video on it. And we are going to mark you on your transcript. So this was like, students really enjoyed it, and we enjoyed it too, because the kind of things they came out with. So the onus was not on us to search for the examples, right? And already in the process of search, they understood that, some things cannot be done. So it was a great, it was learning for us as teachers, but also for them. They really enjoyed it.
So unless there are pressing questions, and because you have questions, maybe you can take it. Yeah, you have. Yeah, please go.
My question is, recently I got an opportunity to teach MDC, multidisciplinary course, as an intellectual property.
Can you give your background? You are at IIT, or where are you currently?
Sir, currently I'm an assistant professor at Christ University, NCR, Ghaziabad.
Okay.
So therein we have different departments. So I got an opportunity recently to teach intellectual property to people who are interested, who are belonging from different departments like psychology, BSc, BBA. I found immense interest in them, but however, I'm feeling an obstruction and a problem that when I'm teaching them, I'm more crossing the legal. When should I stop the legal principles, teaching them legal principle, and when should I start? And how can I cater their needs? The main agenda which I have in my mind is that to make them aware how intellectual property in their respective courses can help them in future, like psychology, economics, BSc, everyone is there. So I'm seeking suggestion from the experienced teachers, experienced panel, that although they are interested, copyright law, I introduced that how their Snapchat or Instagram activities can enhance or obstruct their legal rights. But so far as their department related issues or objectives are concerned, I'm very much confused. How can I cater the needs?
Yeah, how
Thank
do you
so
teach
much.
IP to psychology? Wow. Philosophy, at least I can understand ethics, morality, and all of that of IP, but psychology, I don't have a clue. Anybody?
So it's a mixed crowd, psychology, BSc, BBA, and everyone is interested. So where should I draw the boundary? And
Other.
I mean, my immediate, what we call as rough and ready advice in practice is, uh, see, I think in when you have a mix of students, I've done that once at the University of Strasbourg. So of course, the subject was pure focus is patent law. So when I was in Geneva, I used to do guest lectures there because the Strasbourg University used to train students to give the EPO exam. So if you want to become an examiner, you have to train and then give an exam to become an examiner at the European Patent Office. And we used to have a wide, students from very, very different science pure science, no arts or humanities or nobody, but only pure science background because that's the qualifying criteria. The idea, at least what we used to do there was, we used to take a sample of subject matters, right? I don't know. I can't imagine for psychology. I probably have to sit and research on it. But we used to have a example practical case from say chemistry, one from insecticide, one from pure mechanical, one from electronic, right? And we used to lay out a scheme of invention. All right. So the researcher sat on day one. He did this. Then this is his research notebook after 25 days. This is how he's built his research notebook. Now he is going to file a patent application. So how do you build for that invention? How do you build the initial invention disclosure? Now, from that invention disclosure, how do you make it a complete spec or complete specification? Then, when you have a complete spec, how do you now design the claims? And so now, say these claims now go into the EPO, and now you're suddenly asked to amend. So, if I add this limitation, if I delete this limitation, how do you hit 123 EPC? The law on amendments. So, I've generally found that when you have these diverse, I don't know how you'll deal with more esoteric subjects, but I've generally found to take a case study and walk that case study from infancy to death is something that works. I've done it in the past, and I found that students were interested in something like this. So that might help.
thank
Yeah.
you so much.
With that, we will end today's session. But I also wanted to, thank you all for joining. I don't want to stay in between the lunch and this panel, but I wanted to make a short announcement. Because Professor Lisa Lucas mentioned the need for capacity, etc. Under this program, we are trying to save some budget, also for the purposes of training of academics. So there's something for the academia that will come out. There's something for practitioners also. there is going to be, say, for example, we have a lot of IP modes, but nobody focuses on IP negotiations and in transactions. So we would like to see, a mediation or a, kind of, competition on IP licensing coming up. So all these activities are there to create a kind of an ecosystem around this program, because we are definitely, going to make some considerable revenue, because the fees are too low, when compared to the kind of things we are offering, or at least we are promising to offer at this moment. But we hope to have that ecosystem, and that has been the thrust of the WIPO Academy also, that to build an ecosystem around, and that is useful to every sector that relates to intellectual property, and we hope to take this ahead. Thank you very much for joining in today. I also thank my team, Nishta, Gunveen, Kriti, Virender, and others, volunteers, particularly Kushi, and who are the ones? Krishna. And everyone who has helped us, particularly from India International Center and National Law University Delhi, including the photography, etc. Thank you so much. Thank you very much. It has been a pleasure to be with you through this morning and till noon. Let's have a sumptuous lunch, hopefully. Thank you.
Thank you. My thing,
Oh,
no
problem.
Sorry,
No problem.
I should have said the line.
No problem.
So that little city,
Okay.
deserve to ask.
Yeah, yeah.